And this matter comes before the court today on plaintiff's motion to compel that appears to be directed at supplemental documentation and also additional continued depositions. So as an initial matter, counsel, why don't you place your appearances on the record?
Good morning, Your Honor. Zach Runyon appearing on behalf of plaintiff.
Thank you.
Good morning, Your Honor. Andrew Krieber appearing on behalf of Defendant Dean Transportation.
Thank you.
Good morning, Your Honor. Kyle Slinsky appearing on behalf of Kentwood Public Schools.
Very good. Thank you, Mr. Zelinsky. Okay. All right. So, this, and I have to apologize here. The one I received a judge's copy of, I have Dean Transportation and Mr. DeYoung's response to the motion to compel discovery. However, the judge's copy of the motion to compel discovery itself and any response filed by Kentwood, I did not receive. So I guess I'll give plaintiff's counsel the opportunity. It does summarize here, Mr. Runyon, at the top of this, what you're looking for, that to be additional videos, corresponding vehicle camera viewing reports, a termination file for Mr. DeYoung, and then continued depositions. Is that accurate?
That is accurate. So I'm not sure why you didn't get the judge's copy of my motion. I apologize for that, Judge. So I'll just briefly give you an overview of the facts and summarize what's happened and what I'm looking for.
Very well.
So this case arises out of a young autistic nonverbal child who attends Kentwood Public Schools. During the fall of 2022, she was being transported to and from school on a bus that was operated by Defendant Dean, and the bus driver was Defendant DeYoung. Sometime in December, Shannon Sample, who is the mother of ES, gets notified that Dean and the school district have obtained video that show that her daughter was being abused on the school bus by another student. At the time my client is informed about this, the school district and Dean say there's only 2 videos. So we filed a lawsuit. We request all videos related to ES in the bus, and Dean tells us there's only 2 videos, December 13th and December 15th. And at that time, we have no reason to dispute that. So we move on to depositions, and we find out in one of the depositions that there's a 3rd video. We don't know when it's from, but we just get told during a deposition there's a 3rd video. So I asked for it, and it takes several months, but Dean turns over a video from October 31st. Okay. And here's why that's interesting, Judge. And that's October 31st, 2022. We have confirmed that the chips that are on the buses that capture these videos overwrite themselves every 14 days. So for Dean to be in possession of a video from October 31st of 2022 means that they had it since the beginning of this litigation, and there's no reason they shouldn't have turned it over when we first requested it. The other issue, Judge, is that there was no documents associated with the video when they produced it. And we've learned in discovery that every single time a video is pulled from the bus and it's watched, Dean fills out a report that says who requested it, why they requested it, and who watched it. And that's a very, very important piece of paper in this case, because we need to know why they have the October 31st video and who watched it. Now, since I filed this motion, Dean has actually produced 4 more videos that, again, are now coming a year and a half after we filed this lawsuit. And they show the same thing. They show my client being abused on the bus by the same kid with the same school bus driver. And again, no documents are associated with them. And we don't, I've asked everybody who works for Dean who I've deposed so far, is there any reason why there would not be a vehicle viewing report with the October 31st videos and the videos that have been produced after that? And everybody has said, no, that is 100% documented every time in a vehicle viewing report. And they've also said they never destroy these documents, that their policy is they keep these documents forever. So there's absolutely no reason that we don't have this. And another important fact, Judge, is the chips where the videos are stored gets taped to the vehicle viewing report. So for Dean to give me the October 31st video, they would have literally had to have taken the chip off of the vehicle viewing report and downloaded it in order to send it to me. So there is no reason why we don't have that report. Okay, so I'm asking that that be ordered to be produced within 7 days.
Well, now it appears to me, and as I said, I only have the benefit of Dean's response, that their response was, well, some of these videos, it turns out, were not sent to Dean headquarters, but rather, were retained in some satellite office. And hearing that makes me a little curious as to whether or not the official report on viewing those videos was actually filled out or not, or if some employee stuck these in their desk drawer and said, gee, I wonder if I'll ever need these, kind of situation like that. And Dean is now belatedly, figuring that out because they've been alerted to the fact that this has been happening, but not in the normal course of business. What are your thoughts on that?
Well, Judge, I can help with that. So the vehicle viewing report is filled out before the video is even pulled from the bus. So in order to get the video chip from the bus, Dean fills out, or the Dean employee requesting the video fills out the report, hands it to the bus mechanic. The bus mechanic takes that report, goes to the correct bus, and pulls the chip. And then the chip is then taped to the report, and all of the reports are kept by somebody named Linda Dixon. Okay, Linda Dixon does work at a satellite office. She doesn't work at headquarters, but she is the person who has all of these vehicle viewing reports. They're kept at her office. So the fact that central office didn't know about the video, I think is questionable in itself, but it actually has no bearing on whether or not this document exists, because it's not filled out by central. It's filled out by Linda Dixon.
So in other words, if the chip came out of the bus, it would have had a report. It would have been taped to the report if things were going to Hoyle. It wasn't a case of a random bus driver saying, hey, I'll give that to Linda Dixon, just myself, because I think it might be valuable, but rather, if it was going like it's supposed to, it would have the piece of paper corresponding to it.
Exactly. There would be that paper. And we've also had it confirmed that there would also be an incident report, and that's regardless of whether they think there's anything of note on the video once they view it. But they don't. I just want to make clear, Judge, they don't view these videos as a matter of course. They only view them where there's a report to Dean that says something happened on the bus. We want you to watch the video.
Otherwise, the chip sits in the bus and records over itself a number of times. So you get a limited slice of activity that happened on the bus.
Exactly. So, that it's been confirmed multiple times those documents exist. And what another interesting thing is, I asked Mr. Kreiber when we had depositions last week, I said, why haven't you guys given me this report yet? And he actually told me off the record that he had it and they were going to give it to me, but I still don't have it, and I don't know why. And I want to bring up another set of documents, which makes me believe that this is somewhat being done intentionally, Judge, and I don't say that often.
Now, just if I can pause you, I don't see, and again, I'm not... I do. One of the things you're requesting are these video camera reviewing reports. However, I don't see that incident reports were necessarily the subject of this motion. Is that accurate?
Well, I put as the subject of documents I'm looking for all documents associated with the videos. And I didn't learn until after I filed the motion that incident reports are always created with these videos. So that's why that wasn't in the motion specifically. But I would
believe it's broad enough to encompass that based on the discovery request.
Exactly.
Okay.
Okay. The next set of documents that was in my motion were documents related to David DeYoung's termination. And these documents have been of particular frustration for me because during the initial set of documents that were produced to me from Dean, all of the documents indicated that DeYoung had not been terminated at all, but instead he was briefly suspended, went through retraining, and started driving buses for Dean at a different school district. I later found out, again, in depositions that DeYoung had been terminated, but nobody could tell me why. And it had been confirmed from the beginning of these depositions that there was documentation related to DeYoung's termination. And I kept asking, I mean, for months, Judge, I asked in person, I asked over emails. I said, I want these documents. I want to know why DeYoung was terminated. And I just got no response. So I ended up filing a motion or a notice of deposition for a corporate representative to testify specifically about DeYoung's termination. Okay, that deposition occurred last week. And the corporate representative's name was Jane Butler. I get to the deposition and I asked Miss Butler, I said, what did you do to prepare for today? And she says, well, I reviewed documents related to DeYoung's termination. And I said, well, where are those documents? I have not seen them. I've been asking for years now to get those documents. And she said, well, I don't know why you don't have them, but I reviewed them to prepare for today. And Mr. Kreiber tells me that he produced them to me a long time ago. And there was a big disagreement about it because I don't have them. So I literally had to go through every document that was produced in the case with Miss Butler. And Miss Butler confirmed that I did not have any documents related to DeYoung's termination. So after that's confirmed, Miss Butler and Mr. Kreiber changed their story and say that these documents don't exist. On the record, Judge, they literally took a 180 and said, well, these documents don't exist. And that just didn't make any sense to me. So I shut down the deposition. I said, I don't think this is true. I think you guys have these documents. You haven't given them to me, and I need to be able to see these documents before continuing with this deposition. And Miss Butler couldn't even tell me the date of termination. So it was really just going to be futile. Well, after telling me the documents didn't exist, they turned them over to me 3 days later. So late last week, I finally got the documents after they just told me they didn't exist. And so I'm getting very frustrated with this, Judge, because it's becoming quite clear that they have these documents. They're not giving them to me for reasons I don't understand. And as a result of this, I've taken multiple depositions where I'm going to need to ask these witnesses, questions about the new documents I got. I mean, I'm obviously going to have to do the new corporate representative deposition. I'm going to have to redepose Linda Dixon, who was DeYoung's supervisor. And I was told over the phone by Dean's attorney that she was the one who requested the October 31st video to be pulled from the bus. So I need to ask her, A, where's the document? B, why did you request this? And C, why did you not inform my client about this back when it was happening? I needed to depose DeYoung again because when I deposed him, I only thought there was 2 videos, and now I have 6, and I need to ask him about those. And because we have pretty clear-cut evidence that Dean has been in possession of all of these documents since the beginning of this litigation, and they've just been withholding them, I don't think I should have to pay the expenses to have this done again, because this should have been stuff I had before all the depositions. It should have been things I could have asked all these witnesses when I first talked to them. And so it's unfair to my client to have to incur additional expenses because Dean was withholding documents. And so I think in addition to allowing me to retake the depositions, I think Dean should be sanctioned for failure to supplement discovery. And that sanction should be they have to pay costs and attorney fees incurred as a result of redeposing these individuals.
Okay, and that's the cost, the attorney fees, obviously the cost of you attending, you wouldn't, your client wouldn't normally have to pay the cost, of course, of the other attorneys. Their clients are gonna have to pay that. The cost would be limited to a witness fee and the reporter.
Well, witness fee, reporter, I drive from Detroit to Grand Rapids for each of these depositions. I think mileage would be something that should be paid.
You think you need to do these in person, or can you, now that you've already had an in-person opportunity, can you do some of them or perhaps all of them by Zoom?
Given the severity of this case, Judge, I believe these need to happen in person. And So I wouldn't want to do Zoom for any of these depositions.
Okay, all right. Well, let me hear from Mr. Kreiber.
Thank you, Your Honor. Yeah, I believe you've already made pretty clear on the record here. You've read our response and are well aware of what it says in there. It is just a general matter here. We aren't withholding. We aren't trying to hide any documents. The documentation, including, I guess I'll address the DeYoung termination documents first. We had produced DeYoung's entire employment file back in August of 12th of 2024, but something that we didn't necessarily note in our response hereof is we were involved in discussions with plaintiff counsel pre-litigation. So we had turned over his employment file pre-suit, and we had also collected his employment documentation prior to when he was terminated. So it was our impression and belief that when we provided the files, it had the termination documentation already within it.
When
When it
was
was
he
learned-
terminated? What was the date of his termination approximately?
July, I don't recall off the top of my head, 2023, or does that sound right, Zach?
Yeah, July 2023. So well before I received any documents in this case.
Yeah, it would
Right.
seem like a year would be enough time to get the termination report into the personnel file. I mean, if it was 2 weeks before or something like that, I might understand the delay. At the very least, impression I'm getting here is that Dean's record keeping perhaps leaves something to be desired.
I would I hear what you're saying there, Judge, and I guess the simple summation of all this is I think the compel aspects of plaintiff's motion at this point in time are moot, in the sense of we produced everything that we have. As things come up, as we learn things, we do our due diligence, we recheck the files, we make sure that we get in, if there is something, we produce it, such as these video cam viewing reports. We have asked our client to review to see if they have these corresponding video camera viewing reports. And if we do have them, we provide them. At this time, we provided everything that is known that we have. Same thing
When
with
you
these
say that,
videos.
you mean you're relying on that person at central office, or are they saying, you know what, since we screwed this up at least once with one of the videos, I'm actually going out and, talking face to face to my satellite person out there, who might actually pull these out of the buses and seeing what they have in their desk?
Yes, we are discussing with the satellite offices, the deponents, main office as well. We are going through, and again, if there's anything that's determined that wasn't turned over prior, like the videos themselves, we do produce them as timely as we can. Now, the videos, any delay in producing the videos, as was noted in our motion, is because
You're
those
scrubbing those so you don't have other students identified, their faces identifiable in there.
Exactly, Your Honor. So in
Okay.
terms of the videos, the documentation, again, we produced everything that's known in our possession at this time to
How about
plaintiff
incident
counsel.
reports? Do you agree with what plaintiff's counsel is saying in that each one of these videos, if everything was going according to Dean's policy, we would see a slip of paper that says this is the video viewing report, and then second, an incident report?
Your Honor, what plaintiff counsel said does make sense to me right now. I don't know necessarily that there's always an incident report for a video camera viewing report. I don't know the answer to that, Your Honor. Again, we are happy to follow up and supplement with our clients, do due diligence checks. If we discover something, we're happy to produce it. Whether it's the incident reports, video camera viewing reports, additional videos, or otherwise. Similarly, in terms of the depositions, I'll just first note, obviously, we don't represent Ms. Tani Moore in this matter, so we can't produce her, but notwithstanding, we're not objecting to any continued depositions or plaintiff taking any of the depositions otherwise. I think we've had at least 6 or 7 depositions to date in this matter, and I think another one upcoming in early August here. So we're very clearly being compliant in discovery. And in response to plaintiff's request for the sanctions and costs, I don't believe those are warranted here. I don't believe they're warranted for the several points Your Honor had already pointed out. But as we put it in our motion response here, plaintiff is actually at an advantage to ask additional questions of each deponent after additional discovery has now been exchanged and elicit further testimony. In a similar sense, plaintiff would have borne the costs of the depositions, even if he already had those documents ahead of time, because the depositions would have just taken longer for him to go through the questions. So in that sense, I don't believe sanctions are warranted here. I don't think plaintiff in his initial motion also went through the dean and Vincentio factors for discovery sanctions. Obviously, I don't believe he's addressed those today here, but as we address them in our motion, I do not believe that they're supportive of sanctions in this case.
Are you
Um, it-
requiring subpoenas for the depositions of your employees, Mr. Krieger, or are you just accepting service and scheduling those?
I believe it's the latter, Your Honor.
Okay. All right. No, that seems appropriate to me here. Okay. And you did make an argument in your briefing about attorney-client privilege. It didn't seem to me that, well, at least the incident reports, the video viewing reports, the videos themselves, those aren't going to have any privileged information. I do understand the FERPA scrubbing, and okay, that can happen. But is there privileged information that's implicated in some of the request here?
So, Your Honor, insofar as I understood the documentation plaintiff was referring to, which was that screenshotted sort of document I put on page 4 of our response, that is not what we were asserting is privileged. We had produced that unredacted, just like it was put in our motion response therein. The privilege argument that's kind of tacked in there of is if he was talking about something else that might have been privileged, obviously I just didn't want to, I wanted to protect and not waive that kind of an argument. So if there's something else, but I don't know if necessarily it would even be applicable.
You
So
haven't
to speak.
asserted privilege or produced a privilege log on any of the documents produced to date?
We did, I believe, produce a privilege log for our initial file production. It was very minute. I want to say a few documents within thereof.
Okay, that delineates what you were withholding on the privilege argument, and the rest of it just to preserve the argument. Okay,
Correct.
I think I understand what your position is. Mr. Zelinski, anything to add?
Yeah, I do. Thank you, Your Honor. I guess my main concern is I don't believe all the videos have been provided. There's an incident viewing report from December 16th of 2022 from when this whole incident kind of kicked off and was discovered that mentions that there was videos from December 6th, 7th, 8th, and 9th where the one student who was perpetuating the abuse was absent. And then there was a video from December 12th where additional interactions between the two students was viewed. Those 5 days of videos have never been provided to either party, or I guess either defendant. And I think it's relevant as to what occurs on the videos when the abuse is not occurring.
And you think Dean would have those videos if anyone has them?
Absolutely. Their incident report indicates that they were watched. And I can't imagine why they wouldn't have been saved at the same time that these videos were saved from December 13th and 15th, Your Honor. Beyond that, I guess I take issue with Defendant Dean's statement in their supplemental response that November 1st through 4th videos were initially saved as part of an unrelated investigation. If there's no video reviewing reports, incident reports related to these videos, I guess I'm unclear how they know they're related to an unrelated investigation. It's quite relevant to my client as to who knew of these videos and who they were all shared with. So if they are from an unrelated investigation, that needs to be made clear. If there's other students' information on those documents that they're worried about providing, that can easily be redacted to a point where it just clearly shows that it wasn't an investigation into the students involved in this case. I think that those documents are highly relevant and need to be provided, or at least there needs to be an explanation as to, this October 31st video, is it on a separate chip than these November 1st through 4th chip videos, or was it on the same chip? And if it's on the same chip, why weren't they provided at the same time that the October 31st video was? If they're separate chips, I'd want to know why both of them were pulled, when they were pulled, and who all they were shared to.
Okay. All right. No, I understand. I'm going to bounce back to Mr. Kreiber first on these videos. When you're producing them, Are you doing it in the native? Are you producing a scrubbed version of the chip itself, or are you um, placing those on some sort of video viewer? And in other words, you're giving the content, but not in native format.
I guess I am a little bit confused about your question, Your Honor. When we do
Well,
produce
you're
the
not sending
video,
the chips to, I'm guessing, to plaintiff's counsel and
correct.
making a copy of it, but rather you're extracting a discrete video from the chip.
Yes, correct, Your Honor. And if I may, I guess just to touch on what co-defendant was saying a moment ago. Are you seeking videos where there weren't incidents related to the minor plaintiff here, but there might have been an incident with another student? Was I
Well,
understanding that right, or?
Yeah,
well,
I think
I'm sorry, Kyle, but I was just going to say, just to piggyback off this, the problem is that I requested all videos that show ES from the beginning of the case. And so I was actually hoping the judge would come back to me at some point so I could mention the December 12th video. Mr. Zielinski brought it up, though, Judge. We have testimony, we have documents where they said there is 100% a December 12th video where abuse occurs, and they watched videos earlier in December when the abusing student wasn't there. So Dean has these videos, and there's no excuse for why we don't have them.
And these are videos from December of 22.
December of 22, correct. And with the October, November videos and the December videos, they have had those since the end of 2022 at the latest, because these videos scrub over each other every 14 days. So there's no excuse for this delay when we've been looking for all this. And aside from my initial request, Judge, I just want to make clear, every time I see Dean's attorneys, I reminded them, I said, I need these videos. Where are these videos? I emailed them repeatedly. I said, where are these videos? And I feel like they're either not cooperating on purpose, or they are dragging their feet when they shouldn't be, because these videos are very, very important. And this case has been going on for a long time. We have facilitation coming up in September. And, I think we need an order compelling all of this stuff. And then if they don't produce it, I'll file a spoliation motion, because I have testimony and documents, evidencing that these videos were in their possession after a letter of preservation was sent to them. So we'll get there when we'll cross that bridge when we get there. But I think we need to put a tight timeline on getting these produced.
All right, Mr. Zielinski, you wanted to weigh in on what
I think he touched on what I was going to comment on.
Okay, and just to circle back to Mr. Kreiber's question, you're not necessarily seeking videos that involve other students other than the plaintiff in this case. You're just trying to be assured that all the videos involving the plaintiff have been produced.
Yes, Your Honor. The incident report that I'm referring to is GRSM document production number 314. And it, from what I can tell from the way it's worded, is that the videos from December 6th through 9th only show ES and do not show the other student. And so, yeah, I think those are covered in plaintiff's request, and I think they should have been provided. And I think they're relevant to see, what the different actions of that student are on the bus when the abuse is present and when it's not.
Well, if I may, Your Honor, I mean that a lot of the redactions have been, I believe, of this other student, because they're not a named party in this matter, and therefore are, protected under the privacy statute therein. If I'm understanding correctly, I apologize if I am not understanding correctly, but I don't know how videos where an incident didn't occur on the plaintiff minor here would necessarily be relevant if it was this other student who's not a party in this litigation, I guess.
I could touch on that, Your Honor.
Yeah, go ahead.
I think part of the issue in this video is the lack of response from the Dean bus driver. And part of the reasoning is supposedly because the student made these same sounds and cries every day, not dependent on what was happening. I think seeing these videos where the abusing student is not present and how the plaintiff or how the minor child is acting in those videos, or how the bus driver is reacting to her in those videos, is highly relevant.
Okay. No, I would agree that, right. And since the discovery request encompasses all videos of the student, it would be broad enough to encompass, even the videos of ES where the alleged abuser's not there. And I agree that all the reasons that you said, Mr. Zielinski, those things could be indicated by such videos. So if my order does, encompass all the videos involving ES, is that an impossibly broad or time-consuming process I'm putting you to there, Mr. Kramer?
I mean, candidly, I believe that would be, Your Honor. I'm not saying that we wouldn't engage and undergo the process if that's the order of the court here, but yeah, that would to research all videos from that bus to the extent we have them in our possession, even for incidents that didn't occur upon the plaintiff minor. I have no idea, Your Honor, how many videos that might encompass, how might that be, how long it would take to redact and provide. I don't know.
All right, let me circle back to you, Mr. Runyon. Would that be too broad if I ordered the production of all of those? I mean, what are your thoughts?
My thoughts would be one that's not too broad for a few reasons. One is, again, these videos scrub over each other if they're not pulled from the bus. So all they would have to do is look
So in
for
theory, there only ought to be 14 days at any given time unless the video's been pulled out for some other reason.
exactly. And so it's not like they'd have to go through the entire year's worth of footage. They would just have to look at the chips that have been pulled from the bus that my client was riding on and produce them to us. And what's kind of concerning is Mr. Kreiber's suggestion that he doesn't know how cumbersome that would be because he should have been doing this for over a year. When I first requested it, I had no indication from them that they had not looked for these videos yet. They just have been telling me this whole time that there were no more videos, and then they have been slowly giving us more and more. So they should have been doing this a long time ago, but it's, I would be shocked if there were, you know, videos or chips pulled for every single day on the bus. It
Yeah,
just
you're
doesn't
not,
make sense to me.
even if I order production of a year's worth of video, it's not 365 separate videos. In theory, if no chip was ever pulled, it would still be at most 14, it would be the videos that got pulled during the relevant time period.
Exactly. And Judge, we can actually even tighten it up to this particular school year. So we could say the fall of 2022 school year, which would be August through December, because that is the only time my client was riding this particular bus with David DeYoung.
All right. August through December 2022.
Correct.
Okay. All right. Well, I think I do have, enough information now that I can compile an order. So what I'm going to do is I will order within 30 days the production of any videos involving ES that exist for the time period August 2022 to December 2022, and any corresponding vehicle camera viewing reports that exist, or in the alternative, a statement that no vehicle camera viewing reports are in existence beyond what has been produced already, because it sounds like whether that's company procedure or not, there may not be necessarily the report for every vehicle, and further, any incident report generated per company policy in response to those videos must be produced as well. Did you get that termination file ultimately regarding Mr. DeYoung? Do you think you have that whole thing now, Mr.
I believe so, Judge.
Okay, so I don't need to include that. And within 30 days, well, let's make it 30 days for production, and then within 45 days, dates for continued depositions of any of the defendants who have already been deposed, who need to be deposed as a result, or redeposed as a result of information gleaned from those videos. I'm going to keep that. I'm not going to, this isn't a motion on an order to compel discovery where I normally would grant the costs and fees, but rather, you know, I'm going to save that sanctions motion for if that becomes necessary later. For now, the video and deposition costs will be at your expense and also your discretion, of course, Mr. Runyon, as to whether you do them in person or by Zoom. How you do that, I do note that Mr. Krieger has agreed that he'll accept for all Dean employees notice of depositions and schedule those without the necessity of a subpoena, you know, or its corresponding cost of service, et cetera. So there is that. And does that cover everything that we need to in terms of an order compelling discovery?
That does, Judge. Thank you.
Very good. Can you draft that up for me, Mr. Runyon, and send it out?
Absolutely.